case briefs, and so much more. LSData's got what you're looking for.
An airshow event turned into a legal battle between Don R. Ickes, an ultralight vehicle owner, and the Federal Aviation Administration, FAA, in Osterburg, Pennsylvania, back in 2002. At the heart of the controversy was Ickes' claim that the FAA overstepped its bounds by forcing him to ground his flights due to alleged non-compliance with federal regulations. The FAA issued an emergency cease and desist order, ostensibly to protect public safety during a weekend of flyby demonstrations. Ickes argued that his flights were strictly intrastate and did not impact interstate air commerce or safety. As such, he claimed that regulation under the Commerce Clause was not applicable. Moreover, he posited that the FAA was wrongly classifying his Challenger II aircraft, citing that it was an ultralight vehicle exempt from federal certification and registration. Nonetheless, a whirlwind of infractions seemed to cloud Ickes' aviation history. He had been previously cited for regulatory violations, such as failing to register his Challenger II airplane, an action marked as non-compliance with aircraft guidelines. His authorization to operate the said vehicle had expired nearly a year before the emergency order was issued. The FAA viewed his planned participation in the airshow event as a potential threat to public safety, given these recurring unlawful acts. After what was probably a heated battle in the courtroom, the United States Court of Appeals for the Third Circuit decided in favor of the FAA. It ruled that Congress did possess the authority to regulate the nation's navigable airspace, a channel of interstate commerce. The aircraft, regardless of its operational boundaries, is an instrumentality of interstate commerce and hence subject to congressional regulation. The FAA's immediate issual of the emergency cease and desist order was considered justifiable due to Ickes' disregard for procedural laws and the looming risk he could have posed to the public. The Challenger II, not categorizing as an ultralight, but instead as a two-seater plane exceeding ultralight weight and speed specifications, was a fact supported by substantial evidence. In the end, the court upheld the FAA's emergency order, reaffirming the priorities of public safety and legal obedience.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.